I'm going to talk about defenses to the formation and enforceability of a contract. A bilateral contract is an exchange of promises that is enforceable by law. One party promises ABC in exchange for another party promising XYZ. If a party fails to fulfill one of their promises, then that may be considered a breach of contract. If a party lets it be known that they intend to breach the contract in the future, but is yet to breach it, then that may be considered an anticipatory breach. In either case, the non-breaching party may file suit in court. As a defense, the breaching party might deny that they breached the contract or intended to breach it, and/or they might present one or more vitiating factors. These are factors that would impair the validity and enforceability of some or all of a contract. The idea is that if the contract is actually invalid, then they would not be liable for a breach. Even if neither party intends to breach the contract, understanding vitiating factors and avoiding them during the formation of a contract is important to ensure that a contract is actually legally valid. Also, a lot of musicians are stuck in bad music contracts. If a vitiating factor was present, then that may provide a legal path out of such a contract. Examples of lack of capacity would be if one of the parties was mentally incapacitated at the time of contract formation, or if one of the parties was under the legal age necessary for that type of contract. Contracts involving military enlistment, bank accounts, and necessaries such as food and housing may be valid even if one of the parties is a minor. Also, there are some types of contracts that a minor may enter into, but that a court may allow them to disaffirm or void. California and New York passed laws that limited this right with regards to entertainment contracts. A contract's major terms, such as the parties involved and the promises made, must be sufficiently certain to an objective observer. If they are too indefinite, then that may impair the contract's validity. In some cases, a court may try to fill in the gaps of an indefinite contract via inference rather than deem it unenforceable. In a bilateral contract, both parties must make a promise. One party's promise is the other party's consideration, and vice versa. Some statements may look like a promise, but are not actually a promise because they are conditional, and whether or not the condition is fulfilled is within the control of the promiser. These are illusory promises. For example, Jill may promise to give Jack $1,000 if she visits his house tomorrow. Jill can control whether the condition is fulfilled, so that would be considered an illusory promise. If one party to a purported bilateral contract does not make a real promise and only makes illusory promises, then the purported contract may be considered illusory and unenforceable by law. If a party can change the terms of a purported contract at any time without notifying the other party and giving them a chance to accept or reject the changes, then that may also be considered illusory. A contract must abide by the laws of the jurisdiction that covers it. A contract where two parties agree to rob a bank and split the take would not be enforceable by law. Some types of contracts have to be in writing to be valid. This is because of the statute of frauds. An example of such a contract is a real estate transfer. Title 17 of the United States Code, Section 204, states that the transfer of copyright ownership other than by operation of law is not valid unless an instrument of conveyance or a note or memorandum of the transfer is in writing and signed by the owner of the rights conveyed or such owner's duly authorized agent. Undue influence is when one party takes advantage of a position of power over an especially vulnerable party and causes them to agree to a contract against their free will. The requirements for proving undue influence can vary by jurisdiction, but objective indicators of undue influence are generally the presence of a relationship that places one party in a more authoritative position over an especially vulnerable party, the use of tactics by the stronger party that impaired the other party's free will, and a contract that favors the stronger party. A legitimate threat is a threat to do a lawful act. An illegitimate threat is a threat to do an unlawful act. Duress is the threat of physical harm and is considered an illegitimate threat. If a party entered into a contract under duress, then that contract will usually be deemed voidable by that party. Economic duress is the threat of financial harm. The threat of financial harm may or may not be legitimate. Economic duress may not be claimed where there wasn't a pre-existing contract in place between the parties involved. It may be claimed if a party threatened to terminate a pre-existing contract if the other party didn't agree to a modified or new contract. If a party entered into a contract under economic duress, then that contract will usually be deemed voidable by that party. If the terms of a contract are grossly unjust or one-sided in favor of the party with greater bargaining power, then the contract may be deemed unconscionable. To be deemed unconscionable, a court will determine whether the terms were unconscionable at the time the contract was made. If the terms were not unconscionable when agreed to, but only became unconscionable due to a later change in circumstances, then the contract may not be deemed unconscionable. A mistake is when at least one party's beliefs are not in accord with the truth. If a party is mistaken about a relevant aspect of the law, then that would be a mistake of law. If a party is mistaken about an important fact relevant to the contract, then that would be a mistake of fact. Either type of mistake may be unilateral, mutual, or common. A misunderstanding is when both parties' beliefs are in accord with the truth, however, each party's beliefs are in accord with a different set of truths. For example, let's say I agreed to pay someone to paint my car the color of the sky. If I believed that the sky was blue and they believed that the sky was green, then it would be a unilateral mistake. My belief was in accord with the truth, but theirs was not. If I believed that the sky was purple and they believed that the sky was green, then it would be a mutual mistake. We had different beliefs, but neither were in accord with the truth. If I believed that the sky was green and they believed that the sky was green, then it would be a common mistake. We had the same belief, but it wasn't in accord with the truth. If I believed that the sky was blue, but they believed that I was talking about the night sky and meant black, then that would be a misunderstanding. Both beliefs were in accord with the truth, however, we each ascribed a different set of truths to the term color of the sky than the other party did. A mistake by one or both parties might make a contract voidable, though that is more likely to be the case with mistakes of fact than mistakes of law. With the misunderstanding, though both interpretations of the term color of the sky are technically true, a court may or may not determine that the painter's interpretation was unreasonable given the context. The sky is more often associated with being blue than black. If a court determined that the painter's interpretation was unreasonable, then the contract may be deemed valid or perhaps voidable by me. If a court determined that the painter's interpretation was reasonable, then the contract may be deemed void. A misrepresentation is a false statement that induces a person to enter into a contract. To be deemed a misrepresentation, the statement must be false, must be a statement of fact, not opinion or prediction, and must be material. In other words, likely to induce the other party to enter into the contract. There are three categories of misrepresentation. Innocent misrepresentation, the party making the statement believed the statement was true when the contract was formed and had reasonable grounds to believe it. Negligent misrepresentation, the party making the statement believed the statement was true when the contract was formed but did not have reasonable grounds to believe it. And fraudulent misrepresentation, aka fraud, the party making the statement knew the statement was false when the contract was formed. In most cases, concealing information, in other words, failing to divulge something in order to induce the other party to enter the contract, does not constitute misrepresentation unless the concealing party either has a fiduciary duty or is otherwise legally obligated to disclose that information to the other party. In such cases, the concealing of information would constitute a type of misrepresentation known as negative fraud. Outside of such cases, it's usually left up to the parties to do their due diligence to gather any information that they may need that has not been disclosed by the other party. Frustration of purpose is when something occurs that impairs the reason for fulfilling the contract. The elements of frustration are typically as follows. A supervening act or event occurred that frustrated the contract's purpose. Neither party reasonably foresaw the event occurring. The purpose of the contract has been completely or almost completely destroyed. The purpose that was frustrated was known by both parties at the time the contract was made. For example, Bill and Sue agreed that Bill will rent Sue's guitar for a day for $100 so he can perform a show that evening. However, that show was later canceled. Though Bill and Sue could still fulfill their contract, Bill's reason for doing so has become frustrated, and he could use that as a defense to prevent the contract from being enforced. Impracticability of performance is when something occurs that partially, though not completely, impairs the party's ability to fulfill the contract. For example, Bill and Sue agree that Bill will rent Sue's guitar for a day for $100 so he can perform a show that evening. Sue is supposed to bring the guitar to Bill's house. However, a line of severe storms sweep through the area, and Sue is unable to make it to Bill's house that day. Performance of the contract has become impractical, and Sue could use that as a defense to prevent the contract from being enforced. Impossibility of performance is when something occurs that completely impairs a party's ability to fulfill the contract. For example, Bill and Sue agree that Bill will rent Sue's guitar for a day for $100 so he can perform a show that evening. However, before the exchange, the guitar is destroyed in a fire. The contract may be considered impossible to fulfill, and Sue can use that as a defense to prevent the contract from being enforced. Contract law can vary significantly by jurisdiction, so it is recommended to consult with an experienced attorney when negotiating or disputing a contract.